It's a Friday night, and you're finally kicking back after a long, exhausting week. The radio's on, pumping your favorite songs, maybe a little louder than usual, but certainly nothing wild. Then out of nowhere, there's loud knocking at the door. You open the door, and boom, there's two cops staring at you, flashlights in your face, acting like you have just committed a crime. "We had complaints about noise," one of them says. "You're disturbing the peace," the other one says. "Hold up, wait a minute. Your music was up, but it wasn't shaking the walls." You were ready to say you were sorry and turn down the music when suddenly the second cop peers past you to look into your house and says, "We're going to need to come in and take a look for a minute." Search your house over a radio? This is insane. Is this even legally allowed? Or is this noise complaint just a flimsy excuse for cops to get into your house and look around? I'm Jeff Hampton, the people's lawyer, and I've handled thousands of cases and taken over 100 cases to jury verdicts. And I've seen up close how cops stretch vague laws like disorderly conduct and turn innocent moments into legal nightmares. Today, I'm handing you the tools to stop cops cold in their tracks. In this video, we're going to cover exactly what disorderly conduct means, how police twist it to mess with you, the landmark Supreme Court rulings that can protect you, the state-specific laws that can rein in their power, and most importantly, I'm giving you a step-by-step guide to keep your rights protected and stop cops in their tracks. But first, what is disorderly conduct? If you were to ask a cop this in mid-confrontation, I think you'd get something like, "You're just causing trouble, pal." And that's the problem here. It's a catch-all term. Every state's got its own version, but they throw around a lot of vague phrases like unreasonable noise, offensive language, loitering, or tumultuous behavior. Let me give you an example. In New York, penal law section 240.20 says that you are guilty of this crime if you, quote, "with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, use abusive words, or make obscene gestures in public." One officer's annoyance could be another person's normal Tuesday night vent session after a bad date. In Texas, you're guilty of disorderly conduct if you use, quote, "abusive or obscene language in a public place that tends to incite an immediate breach of the peace." Notice the wiggle room there. Who decides what's abusive? Who decides what's immediate? These laws are a complete and total disaster because they were originally designed to actually stop real public disruptions. Think fistfights breaking out in a bar, or maybe obscenities being yelled in a park where it's rattling families. But the way these laws are written are, believe it or not, by design. The fuzziness in these laws hands cops a tool to tag almost anything they don't like. These laws evolved back from the old days of the vagrancy and loitering laws, straight out of a Charles Dickens novel. In 1972, the Supreme Court took a sledgehammer to one of these in Papa Christou versus Jacksonville. Now, back in the 70s, Jacksonville, Florida had a law so broad it criminalized what they known as, quote, "rogues, vagabonds, and night walkers," which basically meant anybody the cops did not vibe with. The court said no way. This law was written way too vague and gave way too much power to the police to arrest anybody on a whim. Justice Douglas wrote that it gave police a blank check to target whoever they wanted to, and they usually targeted drifters or minorities. Sound familiar? But here's the legal concept you must know. Disorderly conduct under modern laws is supposed to have a public dimension to it. For example, New York's top court said in People versus Manafo, and I quote, "A person may be guilty of disorderly conduct only when the situation extends beyond the exchange between the individual disputants to a point where it becomes a potential or immediate public problem." So shouting at somebody in your house in a private place? Not so much. But drawing a crowd or inciting a mob? That could be totally different. But here's the catch. Who decides what is public or what's being disruptive? Too often, it's the cop staring you down, and his threshold's always going to be very low, and his expectation is that if you do anything even mildly offensive to him, get ready for disorderly conduct. Which brings us to our next point. How do the cops really use this as part of the game to use disorderly conduct as a pretext to get what they really want? Number one, they'll use it to search you. Maybe they think you're being too loud or disruptively weird, so they use it as a pretext to now pat you down or search your backpack, and the next thing you know, they're coming up with disorderly conduct as a way to claim they have probable cause. The second way they use it is to escalate the encounter. Maybe you ask, "Officer, why are you bothering me?" Suddenly, your question was disorderly. Boom! Now they're detaining you and you've got cuffs on you. Number three, maybe you pull out your phone to record and now they retaliate against you by claiming you're disturbing the peace because you're standing too close to what the cops are doing. Then number four, the classic crowd sweep. Maybe you're at a bar that's closing, or maybe you're at a protest, and all of a sudden the cops start rounding up everybody they can that they think is too mouthy, and they claim you've now committed disorderly conduct. Don't believe me that cops will use you being too loud as a pretext to search you? Check out this video of cops in Childress, Texas that come out to a house to investigate a noise complaint, but in the process of doing so, they completely ignore the law and violate the rights of these homeowners.
Somebody called and complained about loud music, and I talked to them.
10 o'clock, so I mean,
it doesn't matter. It's disorderly conduct. Oh, it does?
It does. Because
do you want to go to jail for it?
I can't go to jail for that. I know,
yeah, you can. It's disorderly conduct. You think I don't know the law? 213, meet me over here. Turn around and put your hands behind your back.
You can't arrest me.
Yes, I can.
You can, sir.
Oh, yes, I can.
Did this look like a cop who had already decided he didn't like this kid and was going to arrest him? It did to me. In fact, the cop shows up claiming he's there for a noise complaint. But did you hear any music at all? Did you hear any loud noises? I didn't. Now let's remember here, the only way the cops can get into this man's house as he turns around and runs back inside his home is if number one, they either have this man's consent, which you're going to find out they don't. Number two is that they have a valid search warrant, which they don't have a valid search warrant either. Or number three, they have exigent circumstances. But remember, exigent circumstances must present some type of emergency situation that limits the police officer's ability to have the time to go get a warrant and come back out. Something like somebody having a medical emergency, a fleeing felon, or maybe somebody actually destroying evidence. None of that is present here, and you'll see that here in just a moment. Instead, the cops are showing up, and they'd already decided they didn't like this kid, and they were going to do whatever they could to make sure and arrest him. There's a predator hunting you. No, not some wild animal. It's actually much worse. It's quiet, it's patient, and it doesn't need claws. It's armed with interest rates, late fees, and collection calls. That's right, I'm talking about debt. When I was in law school, I was maxed out on credit cards, living paycheck to paycheck and completely stressed out. I seriously wish PDS Debt had been an option back then. PDS gets it. They understand your specific financial situation. Whether it's credit cards, personal loans, collections, or even medical bills, PDS Debt has customized options to help you out. They go beyond the numbers. No minimum credit score and no shame. Just real help to save more, pay off faster, and maybe, just maybe, put a little bit of peace back in your life. Stop living in debt. Get your free assessment and find the best option for you at pdsdebt.com/HamptonLaw. You're just 30 seconds away from starting to get out of debt. That's pdsdebt.com/HamptonLaw. Oh, and by the way, what basis does this cop actually have to enter into this house? None whatsoever. You have to understand that in order for the cops to even establish that a noise violation had taken place here, they'd have to be 50 feet away from the location and be able to show a 65 decibel or higher level of noise coming from the actual location from an approved sound meter. The cops were just guessing. They showed up, couldn't even hear any music, and here they go coming into the house. In fact, here is where the cops show who they really are, and they prove to us it was never really about the noise complaint at all. Watch this.
Yes, I can.
You can't. We'll turn it down.
No. You get you're under arrest.
No, sir, you cannot step in my house.
No.
This is the
You
first
Get
time
in here.
You gotta have a warrant to come in.
Hey, don't push me.
You gotta have a warrant to
you're
come in.
blocking
Hey, you gotta have a warrant to come. She just had a baby.
By the way, did you see anywhere on here before they walked in the door that cops received consent to enter into the home? Did you see anywhere in here where they had a valid search warrant or presented that warrant whatsoever? And then finally, there was no exigent circumstances. This is, even if he tried to claim there was disorderly conduct and he came back into his home. This is a misdemeanor offense. It doesn't apply to the exigent circumstances. They were just violating the Fourth Amendment rights of this homeowner.
Baby.
I'm trying to
Hey,
get
no,
you
but
out
hey,
of the way.
You can't
Get
come in.
out of the way.
Hey, you can't. Hey, that's what
He
you
goes
got.
in custody.
You gotta have a warrant to come
He
in.
goes in custody.
You gotta have a warrant to come in.
Yes. And
You
he-
gotta. No, you can't arrest. From what? You
Grandma.
You gotta have a warrant. Come here. You gotta have a warrant.
By the way, never, ever, ever leave your door open for the cops to follow you back inside to your home. If you see cops pulling up to your house, go back inside your house, shut the door, and lock it. Otherwise, you might find yourself with cops doing this.
That's what you're doing. You're harming a baby.
So-
You're no.
Settle.
No. I know my laws. I've been in jail. I read the book and everything. You is not
I
gonna
have
go
been too.
treat her. No. You
Turn
don't,
around.
I'm not gonna turn around for what?
Because I'm putting you
For,
in custody.
for what?
Because I'm detaining
what?
you. I just told
For
you.
what? No, you don't even got a search warrant to be in here. You need a
Go
search.
take him in custody.
Bring the search warrant. Until I see a search warrant.
209 children.
Where's the search warrant? You're in the house.
Now we're going to cover where the law is in your favor. The Supreme Court has started to become skeptical of these vague disorderly conduct laws, so now it's time to break down the heavy hitter cases that help protect you in this situation. Number 1, Terminillo versus Chicago. There was a man that was standing in a public area giving a speech that was riling up some of the people that were there. They liked what he was saying. The cops didn't like it, so they arrested him for disorderly conduct. The court said not so fast. Speech that even stirs people to anger is still protected under the First Amendment. Thankfully, for now, you can still speak your mind even if it's messy or sometimes loud. Gooding versus Wilson. Now this is a crazy one. Georgia's law banned the use of opprobrious words. Now look, I gotta admit I had to look this up, so let's see what the dictionary tells us. Opprobrious words describe something that is outrageously disgraceful or shameful, conveying or expressing contempt and reproach. Thankfully, the court said this law was way too vague. Laws must be razor sharp. It can't create a free-for-all for cops to think anything you say is opprobrious. City of Houston versus Hill. Believe it or not, Houston, back in 1987, passed a law that made it a crime to interrupt cops. Raymond Hill yelled at an officer, a big officer, that was harassing his much smaller friend. He merely said, "Why don't you pick on somebody your own size?" Of course, the cop arrested him, but the Supreme Court trashed this law by saying, and I quote, "The freedom to verbally challenge police without risking arrest is what separates a free nation from a police state." There's your lifeline. These rulings hammer it home. Cops can't just arrest you for ticking them off. And in fact, if your words, your speech, even if it's offensive, even if it's a little bit crude, it is still protected under the First Amendment as long as it doesn't incite to violence. You don't lose your rights because someone's offended, even if that someone that's offended has a badge. But here's the catch. Street-level cops don't always read these rulings, or maybe they don't even really care. They'll still cuff you, betting you won't fight back. I've seen this play out in the courtroom, where defendants don't realize they have a winning hand and they end up folding too soon. Now, we've covered the federal protections here, but did you know that depending on what state you live in, you could be receiving extra Fourth Amendment protections to stop cops from using disorderly conduct laws against you? For example, in Washington, there are things known as farrier warnings. A farrier warning forces cops to warn you that you have a right to refuse consent to them searching you for anything, whether it's your car, your home, your person, or your property. If cops fail to warn you in Washington, anything they seize is inadmissible in court. What about Texas? In Texas, if a cop tries to claim that you used disorderly conduct, some sort of offensive language, it can't be that it just bruised his ego. You have to show that it affected the public. In Mathis versus State, the highest court in Texas threw out a charge against Mathis because even though Mathis was yelling at a police officer, there was no proof that it created any public alarm in the things that he was saying. Finally, in Oregon, the state constitution there guards speech like a vault. In State versus EJJ, a teenager was yelling at a cop because he didn't like the way the cop was treating his sister during arrest. So the officer arrested that teenager for obstruction. But on appeal, the court ruled that verbal pushbacks on cops for the work that they're doing is constitutionally protected under their constitution. Now, every state has its own little strange quirks. For example, New Mexico has a very, very strange one. Their law says, and I quote, that you cannot touch a house insolently. That can trigger an arrest. Now, I had to look this up, what that means here. So when you look at insolent, it's not a word we use very often. The word insolent means to show a rude and arrogant lack of respect to the home. So here's what you need to know. Federal law is your baseline. Those are your basic rights. But your state laws might provide you more protection from these horrible, vague laws of disorderly conduct. So here's your payoff. What are the battle-tested moves that you can make when you find yourself in this situation to protect yourself, to make sure that cops don't violate your privacy rights and you protect your freedom? Number one, stay ice cold. Be cool as a cucumber. Cops are hoping that you'll get upset and infuriated as at them trying to come and use this noise complaint against you. They will then take whatever elevated sense of emotion that you have, they'll use it against you and try to claim you're either now being too noisy or maybe you're being disruptive and try to come up with a new reason for why they can detain you or arrest you. In fact, I've actually seen officers say that the difference between assertive and disorderly is your tone and your attitude, which is ridiculous. It's crazy to think that police can try to use that as the basis, but that's how they're measuring it when they show up. Number two, know your rights and assert those rights. You always have a right to remain silent. You always have the right to refuse a search, and if you're not being detained, you have the right to walk away from the encounter. The best way to know is to look at the officer, don't answer his questions, but say, "Officer, am I free to leave or am I being detained?" If the officer says that you're free to leave, turn around and walk away. Don't angle for anything else here. The more you talk to the officers, the more you give them a legal justification to try to claim they can detain you because they are somehow believing now you're being disorderly. Number three, don't physically interfere with the officers during this portion and don't invade their personal space. Now look, I'm going to tell you, I don't even like saying that when I say it. But many times the difference between whether an officer will now determine if he thinks you're being a threat to him is based upon how close you are, the tone for which you say things, whether you're screaming, whether or not you're getting too close to him and now he claims that his officer's safety is at risk. These are the things to think of to remain in control of not only your emotions, but in control of the situation. For example, maybe you're gesturing in a very frustrated way and you're close enough to the cop that he thinks your rapid movements meant you were trying to actually swing at him or hit him or maybe grab in his direction. Now the cop's going to use it as a basis to grab you, throw you to the ground, claim that you were acting in a threatening manner, and now you're facing another charge. Number four, when you use your words with the police, use them wisely. For example, calling a cop an expletive pig is legal under the First Amendment. It's free speech. But I can guarantee you the police officer is going to use that as a reason to arrest you. I already know. I know some of you may comment and talk about this and say this is ridiculous. Is he being a bootlicker? What I'm trying to tell you is how important it is to recognize what you say and what the cops are going to actually do. There's the reality of what your constitutional rights are, and then there's the pretext for which the police will use what you say as a basis to find a reason to take you to jail. Number five, be aware of your surroundings. For example, if you are in a public place, maybe you're in a protest, you have more freedom now because of the expectation that you can say certain things, maybe even say certain slogans, and this is protected. Not only is it protected First Amendment speech, but now that you're going to be talking about the police officers are not going to be able to claim that somehow you were threatening them when you're in a public arena and there are others that are there. On the flip side, if it's just you and a couple of officers on a private street, and now all of a sudden you're sharing exactly how you feel about these officers, you can guarantee the police officers are now going to claim you were creating a disturbance and get ready for a disorderly conduct arrest. Ironically, the more isolated the setting, particularly if you're in a residential area, the more easy it is for the cops to try to claim you were disturbing the peace. Number six, if you're going to vent about how the officers are treating you or someone else, vent directly to the camera and not to the officer's face. Here is a savvy trick that many activists use, and it very much helps them if they end up being arrested. What you can do is if let's say you're at a traffic stop or an officer approaches you, instead of actually looking at the officer and yelling at the officer, you can actually take out your phone as you're recording and you can actually speak and narrate the entire situation to the phone, and you're not directing anything specifically to the officer, but you're actually recording everything to show how the police are improperly handling the situation. For example, if the officer is denigrating you or maybe he's violating your rights, you can look at your phone and you can say, I can't believe this officer is harassing me and violating my rights for no reason. Now, all of this is being recorded, but you're not directing it specifically to the officer, and no reasonable person would believe that the officer's safety was at risk. Police officers will not like it, of course, but they're going to be hard-pressed to substantiate being able to arrest you for anything like disorderly conduct when you're doing nothing more than exercising your First Amendment rights to record the entire situation and narrate what's happening. Number 7, record, and then record. I cannot stress this enough. If you have a phone, please use it, because video evidence is your best friend if things go south. A video can show that you were not acting in an uncontrolled, violent way or causing some disturbance in public. In fact, that video can show that the officer was the one who overreacted and was using this so-called noise complaint as a pretext of your disorderly conduct, supposedly, as a reason to actually arrest you and take you to jail. A word of caution here. If the officer is already on you and you go to pull out your phone, you better make sure and say what you're about to do. The officers, and I've seen this happen many times, will use you grabbing for your phone as a basis to claim they thought you were grabbing for a weapon, and they'll use it as a way to throw you down and arrest you, and you never get to record anything. So you want to make it real clear. Officer, I'm grabbing for my phone to record the entire interaction, which is my right to do. Number 8, avoid stacking charges. Here's the problem. When cops decide they want to arrest you for disorderly conduct, they then want to try to see if they can get you riled up and have you resist arrest or attempt to flee, so they can now stack multiple charges against you. So if you happen to pull away, or you physically resist in any way during the encounter with the police, they will now use this as a reason, a justification, to claim you were resisting arrest, which is a more serious charge. Or maybe they'll claim you were attempting to evade arrest, or even worse, cops now try to claim you were attempting to assault a public servant. So there you have it. We've learned some of the strategies and tips that you can take to protect yourself and stop cops from using a noise complaint or some other disorderly conduct charge as a basis to search you and arrest you. But what if the cops come up to your front porch and instead of trying to claim there's a noise complaint, what if they just walk right up to your camera and they cover or disable your porch camera? What can you do here? What are your legal rights? Check out this next video where I break down how to stop cops if they cover your porch camera. See you over there.